This is not a clown show.
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
You, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
Plaintiff admitted that too.
All right, guys.
Hey everyone, today's video features a person using what's known as the sovereign citizen approach in court. And let's just say it did not go well for him. He tried all the usual arguments, claiming he's a living soul, and that the court has no authority over him. The twist? The judge couldn't help but laugh at some of the things he said. Here's the background. The man in question owes money to a credit card company, but instead of addressing it, he denies everything and acts completely unaware of the situation. It's frustrating to watch because the facts are clear. He racked up debt and now wants to pretend none of it happened. Let me know in the comments what you think. Do you believe he really thinks this strategy works? Or is he just trying to delay the inevitable?
We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
So we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
The judge.
Zoom court appearance breakdown. When the court session started, things took a turn the moment he joined the Zoom call. The mood shifted from serious to surreal almost instantly. His statements were full of confusing legal jargon that didn't make much sense, and he kept misusing basic terms. Had he simply accepted the documents from the court in the first place, he might have known exactly what he was being charged with. Instead, he relied on some questionable internet advice and claimed he didn't recognize the court's authority, as if that would make the case go away. To be clear, that's not how the legal system works. Courts don't ignore cases just because someone says they don't consent to jurisdiction. That belief simply doesn't hold up in reality. The judge's response. What followed was, honestly, a bit tough to watch. The judge gave him multiple chances to speak clearly and respond appropriately, but he kept repeating the same scripted lines. At one point, the judge couldn't help but laugh at the absurdity of it all. This is the kind of moment where most people would realize it's time.
Oh
You will
my
speak
goodness.
one at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes, sir.
Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickhart say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhart, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
To hire a lawyer, but not this guy. He kept arguing, which only made things worse. Unfortunately, it seems like he genuinely believes this strategy will somehow work in his favor. Final outcome and takeaways. In his next court filing, he actually admitted to the debt, but then didn't show up for the hearing. That's the legal equivalent of saying, "I'm responsible," and then refusing to face the consequences. It's hard to believe this was his real plan. Once a judgment is made, creditors have several options. They can garnish wages, access funds from your bank account, or place a lien on your property. Ignoring court orders doesn't make those consequences disappear. Sovereign citizens have become a growing concern, not just in courtrooms, but in everyday life. These beliefs lead some to refuse to pay taxes, drive without licenses, or even live in homes they don't legally own. It's not just impractical, it can be dangerous. Closing thoughts. While some people may find these videos entertaining, there's a serious side to it all. These court delays and false legal claims waste time and resources, while others with real cases are forced to wait. Let me know your thoughts below.
Ready?
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof. that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right,
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you I got a question. Should they have sent me something before they send me this package since the last court date
Sir,
to verify that?
sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
Okay,
they can't
so
tell you.
she's gonna send me a packet and I'm gonna send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't
discovery
interrupt me again. We had this conversation before, didn't we?
Sorry.
We
Go
had
ahead.
this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written requests for discovery, you have a right to do that too. You can send written interrogatories, requests for production of documents, and requests for admissions, same as her.
Do you think this is just misinformation gone too far? Or something more serious that needs to be addressed with tougher consequences? Thanks for watching. Don't forget to like and subscribe if you want to see more content like this. Take care, and I'll see you next time.